We're going to give it a couple of minutes to let everybody get in joining us, and then we will begin. We're going to give it just a moment longer as we've still got people trickling in, so we'll start in just a moment.
Good afternoon, everybody, and welcome and thank you for joining us for today's webinar, What Did I Miss? Hot Title IX Issues You May Have Missed But Can't Ignore. So I'm Emily Tulloch. I'm an attorney at Franczek PC, and I'm joined by my colleague, Jackie Wernz. Jackie and I are both part of Franczek's Title IX team and authors of our Title IX blog, which is title9insights.com.
Yes, and thank you all so much for joining us. We have a great group of folks with us today. We have a number of representatives from colleges and universities across the country, as well as K-12 institutions, and also some of our peers in the legal community. So thank you so much to everyone for joining us today.
And for those of you who aren't familiar with Franczek, we're a law firm of approximately 30 attorneys who focus on labor and employment issues and education law. And before we get started, there's a couple points we wanted to address. So first, you have the ability to type and submit questions at the bottom of your screen. Please feel free to ask questions throughout the program by using this feature, and we will try our best to address any of the questions that you guys asked today. And second, everyone registered for today's webinar will receive an email that includes a link to a recording of the webinar, the handout materials for the presentation, and a link to an online survey. We really appreciate your feedback, and we look to your feedback as we plan future webinars. If you are an attorney watching today and you're requesting Illinois MCLE credit, you need to complete the online survey and request a certificate for credit. There have to be more than 5 attorneys requesting MCLE credit on this webinar for it to be approved for MCLE. And we do want to start out as well reminding you that Franczek webinars are not legal advice. We of course work very hard to provide you the most up-to-date information as possible. But for legal advice on specific incidents, please reach out to your legal counsel or us for assistance on any of those specific issues. Now, let's get started. So when we think about Title IX in 2020, most of us really focus on sexual harassment. And that makes a lot of sense. The new Title IX rules were issued on May 6th of this year, and then they went into effect on August 14th. So while sexual harassment has, and for good reason, taken up a lot of our brain space lately, there have been some other developments in the Title IX world recently that we really want you to be aware of outside of sexual harassment. And this isn't to suggest that you can now ignore sexual harassment completely. There are still lots of requirements related to Title IX sexual harassment that your institution either should have already done or should be making moves to do now to make sure that you're in compliance. We're going to quickly just go over some of the key requirements related to Title IX sexual harassment before we move on to our other topics that we want to cover today.
Right. So first of all, obviously, training of the entire Title IX team, that is something that the regulations require, and also posting those training materials online. So it's very important. What we've said is that, at the very least, we hope that by this point you've trained your Title IX coordinators, but I know that particularly for some of our K-12 institutions, it's been a bit of a struggle getting that taken care of, even that alone, let alone doing the training for the entire Title IX team. But it is imperative that you do complete that at some point in time.
We also think you should consider customizing any template policies and procedures. So if you're a K-12 school that subscribes to PROS, or if you purchased a template for a Title IX sexual harassment policy or procedure elsewhere, make sure you're doing a thorough review to really see what customization you'll need to make so that your policies and procedures fit the unique circumstances of your institution and reflect the actual practices of your institution. So your institution's policies and procedures also need to be posted on your institution's website, just like those training materials.
That's right. And so for higher education institutions too, with respect to these customizations, I know that there were many great policies out there, and that you've all been working really hard to get something in place for the August 14th deadline. But now is really the time to take a look back and carefully to make sure that everything that is what your institution actually wants your process to look like is covered in those policies and procedures. We are still doing higher education reviews, even higher education reviews of materials that have already been reviewed. So this is definitely an ongoing process for policies. And then for posting online, that's going to be particularly important if the Board of Trustees or Board of Education for your institution has not yet formally approved your policies. And the reason that's so important, we know that it takes time for boards to act and for boards to vote policies into effect. But the Department of Education is not going to care that you didn't comply with the requirement to provide those policies and procedures online to your constituency because your board hasn't yet approved them. So we are recommending that you, at the very least right now, that you take the time to post those either in a provisional form, a provisional policy, or in an administrative procedure form so that you can get that information out there now to your community as is required by the rules. And then once your board does pass the policies, you can obviously remove any provisional policy or procedure that you have put up online.
So on the topic of posting online, your Title IX coordinator's information also has to be posted on your institution's website and should be easy to locate. So this information needs to include the name and contact information of your Title IX coordinator, and that should include the office address, email address, and phone number of the person that you've designated as your Title IX coordinator position.
And remember that you can always create a Title IX at yourinstitution.edu or org, or you can always create a more generic email account. And we do recommend that you consider doing that so that you can allow it to be filtered to a number of different people. We here at Franczek believe in that so much that we have a title9@franczek.com email address, so that if any of our clients need assistance and they don't want to worry about having to figure out who to reach out to, they can just send it and someone who's on that list is going to get it. And so think about from your perspective whether that's a good approach to take. It also avoids the risk that if that person's title changes down the road and you didn't remember to update it everywhere that it appears on the website, that at least an individual who's in need of help will know how to contact the coordinator. And then last but not least, you need to get ready for a complaint. You need to make sure that you have all of the paperwork in line that you need in order to address a Title IX sexual harassment complaint if one comes your way. And we have prepared a toolkit that contains approximately 30 forms and notices, and also a very detailed instruction sheet to help you almost as a checklist to work your way through an investigation if one comes. And then there are also checklists in that, as including record keeping checklists and other documents of that sort to help make sure that you're meeting the requirements. So you want to make sure that you have some kind of toolkit or toolbox available for your team so that when they do get a complaint, they're not having to think about drafting letters that meet all of the mini notice requirements in the new regulations. So we are going to have a little bit of polling here at the beginning before we get started, just to see kind of where you are in your Title IX sexual harassment compliance process. And to join the polling, I recommend that you use the web version here, and that you go either, you can go on your phone or you can go on a browser on your computer to pollev.com. And when you get there, you're going to type in the word Franczek into the space that comes up where it says join presentation, and then it says username, and you're going to type FRANCZEK into that box, and that's going to take you to our first question. You can also send a text. It says text a code. The code is Franczek, so you can text Franczek to 22333, but you do get charged for texts, and I actually find that the web version is much easier. Once you've done that, oh, also I should point out that at the top of the slide here, that information on how to get in is there in case you need it. And you also can let us know by chat if you need this information. And while you guys are voting, I'm going to tell you a couple of things about, or respond to a couple of questions we received in the chat. One of them is, will a recording of this session be provided? The answer to that is yes. Almost all of our webinars are recorded and they are posted on our website under events. If you look at past events, you can find links to our webinars, which are hosted through YouTube. So definitely check out our YouTube channel. We also will send out an email at the end of this presentation to include a link to the video recording and also a link to the materials. Please note that if you are watching this for CLE, you do need to watch it live in order to be eligible for the attorney's continuing legal education. And then there was another question of how long is the webinar today? Good question. So we allotted an hour and 15 minutes for ourselves. Usually our webinars are an hour, but we weren't sure how many questions we would get. So we are happy to stick around for as long as you have questions. Okay, I won't say as long as you have questions, but we are willing to stick around and answer questions up to an hour and 15 minutes in length, but our programming itself should be less than that. All right, so we've got lots of voting here, and I should have said that not to worry because this is anonymous, so nobody knows, nobody's gonna know whether your institution has done these things based on your voting. All right, so it looks like our question here is, my institution has finalized its Title IX sexual harassment policy and procedures and posted them on our website. And we have 59% of you saying that's true. Great job. We know you've been dealing with a lot these days, so that is exceptional. For those of you who are saying false, again, don't stress about it, but 2 bits of advice. Number 1 that I already gave you, which is make sure to post something provisional on your website. I would go ahead and do that right away. We are recommending that be done in an area of the website that addresses a non-discrimination commitment. And that contains more general non-discrimination information. but that also would include a link to any provisional policy procedure. And if you need that kind of language, we have it off the shelf ready to go, so just let us know. All right, so our next question, Emily, are you going to take this one?
Yeah, so our next question is, my institution has trained its entire Title IX team, meaning your coordinators, investigators, your decision makers, and your informal resolution facilitators, as required by the new rules. So I'm seeing some answers coming in right now. We have 50-50, so we're about split, saying that yes, my institution has trained our whole Title IX team, and some saying no, I haven't. Again, just to reiterate what Jackie said, great if you guys have gotten everybody trained. If not, that's just stuff that you can, those are steps that you can be taking now to be scheduling some of those trainings. You know, we have put together basic trainings to kind of get the lay of the land for your whole team. And then we've also created some very in-depth trainings for each of the members of your Title IX team that we already have prepared if you are looking for an avenue to get those trainings done.
Yeah, and there are some additional things to consider as far as making sure that you've complied with the training requirements. So of course there are specific trainings, like Emily mentioned, like the ones that we've created that specifically were created to comply with the requirements. But there are also a lot of other resources available, including, as I mentioned, on our website. We do have some general basic trainings that we did back when the rules were first released that are certainly better than nothing if your team hasn't watched them. So if you are interested in that, definitely reach out to one of us, and we will pass those links to those free trainings along to you. All right, so our next question is, the risk if my institution fails to comply with the requirements of the new rules. So in here, I should have worded this question a little better. By requirements, I mean the training, the posting, the policy language updates. What are the risks here? So is it A, an appeal by someone who is involved in a Title IX sexual harassment complaint? Is it B, an OCR complaint by someone who is involved in a Title IX sexual harassment complaint? C, a lawsuit by someone who is involved in a Title IX sexual harassment complaint? D, an OCR complaint alleging a procedural violation even if there is no pending sexual harassment complaint? Or E, all of the above? And you guys aren't being fooled by this question. You know that this litany of things that could happen if you aren't in compliance with these regulations, all of them are a possibility. So we sort of expected, I think, before the regulations went into effect, and at least I expected that we probably would see mostly A, B, and C as responses. However, as I think Emily is gonna tell us about, if I can get my slide to change, there we go.
Yeah, so we've been asked this question a lot about what the potential consequences might be. And like Jackie was saying, until recently, we really thought that there weren't going to be all that many until your institution received an actual complaint.
That's right. So most of you know, if you've been coming to any trainings that I do or any of the webinars that I've done on Title IX, you know that I worked at OCR between 2016 and 2018. And from my experience, it really wasn't OCR's thing to go out looking for procedural violations without some actual complaint from someone in the community. And even when they would do compliance reviews or directed investigations where they would go out and, kind of hunt you down and look for something without receiving a specific complaint, usually what they're looking for is information that's publicly available that suggests that there is a problem within the community, that there are actual complainants. And so, I just did not necessarily expect that we would see OCR going out and looking for procedural violations where there wasn't someone in the institution who was claiming that, hey, this institution didn't address our civil rights issue correctly.
Right, but last week, SAVE, which is the Stop Abusive and Violent Environments, they're a Maryland nonprofit that says they're aimed at ensuring fairness and due process in colleges and universities. They filed this complaint that we have up on this slide with OCR saying that they've reviewed 50 different college and university websites and found that 65% of them had not yet posted any of the required training materials. So as a result, they actually filed complaints against some of those institutions that were out of compliance.
Right, it's really interesting. We don't know what OCR is going to do with this, and they could say, no, we're not going to look into it. However, we do have some evidence in the past of OCR looking at procedural violations even where there wasn't a specific complainant. And I'm specifically thinking of the Section 504 and ADA complaints about website compliance. And so I did a lot of those when I was at OCR. And, you know, we would usually use a little bit of a shortened complaint process to try to get to resolution pretty quickly to just help the institution update their websites to come into compliance, and maybe we'll see something like that emerge. Wouldn't be super surprised, but you know, we definitely know now that there are people out there looking to see if you have complied with all of those requirements that were on that slide with the checkpoints. So if you haven't and you need some guidance on how to get there, definitely reach out to your legal counsel, reach out to us, so that we can assist you with at least getting your bases covered. So the next time one of these complaints is filed, it's not your institution that is there.
Yeah, and while we kind of wait to see how this plays out at OCR, you know, our real takeaway is that there may be some teeth if your institution isn't in compliance at this point. So if you, again, are concerned that you may be in this boat, we've created those comprehensive training packages, policy review options, and, you know, toolkits for investigations that'll really help you avoid some of these types of risks.
All right, so we are now to my favorite slide in the presentation today, and in the impetus for our title, which is, all right, so we've spent some time talking about Title IX sexual harassment, but as promised in our blurb leading up to this, there have been quite a few things that have been happening in the world of Title IX that really don't have anything to do with sexual harassment or these new Title IX sexual harassment rules. We have been listening to a lot of Hamilton in my house and watching a lot of Hamilton in my house. We have an 8-year-old and a 6-year-old, and they are obsessed. And as most parents these days, we're willing to do anything we can to keep them occupied while we're all at home together. So we've been watching a lot of it. And so I can't help but think of a great song. The character is Thomas Jefferson saying, while he was off in France, what did I miss? So that's what we're going to talk about. We're going to talk through kind of what might you have missed while we've all been thinking about Title IX sexual harassment. So to give you a little bit of a roadmap of what we're going to talk about for the next half of our session is we're going to start out with a discussion of the rescission of Title IX guidance that we've seen in recent days, OCR's newly publicized stance on certain LGBTQ student right issues, OCR's updates to its case processing manual, and then some rules on religious institution exceptions at the very end.
Yeah, so late last week, with really no apparent discussion, the Department of Education withdrew several OCR guidance documents that relate to Title IX that many of us have really become familiar with over the last few years. And it's seemingly in the wake of the new regulations that govern how institutions adjudicate Title IX sexual harassment complaints. So while the move wasn't very public, the Department of Education had previously talked about and stated that it really wanted to move away from using guidance documents So its move to withdraw some of these existing guidance isn't really all that surprising. But you may remember the department previously withdrew guidance related to transgender students and sexual harassment that were released by the previous administration. But now the department has also rescinded its 2001 guidance on sexual harassment, which I know a lot of us were looking to before these new rules went into place. The 2017 question and answer on campus sexual misconduct, and their 2015 resources for Title IX coordinators. In part, the department really withdrew some of these guidance documents because they included a lot of inconsistencies with the new Title IX regulations and the process that your institution will go through to address Title IX complaints. But the withdrawal did go into effect immediately, so your institution can no longer rely on any of these guidance documents. It really seems as though the department believes institutions don't need anything other than the new regulations to operate, which isn't completely fair. I do think that there was a lot of really good analysis and great examples in some of these rescinded materials. I know we referred a lot to the 2015 Title IX coordinator materials for those of you who may be new to the role. But I will say that some of the content of these guidance documents may still likely be useful to you as you kind of navigate this new Title IX sexual harassment investigation process or a new role potentially. But do be very careful about what you use, as again, these documents are technically no longer in effect. You can't rely on them for your investigations. And because there was really no additional guidance on the Title IX sexual harassment process, we do recommend reaching out to legal counsel if you have any uncertainties as to how to move forward. So the Department of Ed did leave some of its guidance in effect. They mostly pertain to athletic activities, so they left some of their guidance documents and Dear Colleague letters on intercollegiate athletics, their three-part test to measure accommodation of student interests and abilities in high school athletics, and athletic activities that are counted for Title IX compliance. And then another bulk of the guidance documents that are still in effect relate to parenting and pregnant students. Most notably, I think the 2010 Dear Colleague letter on bullying and harassment, which outlines institutions' obligations to protect students from student-on-student harassment on the basis of sex, race, color, national origin, and disability, is still in effect as well.
Yeah, and Emily just answered a good question that we received, which was whether pregnancy was something that is still covered under the final rule. And I will parse out the answer a little bit more finely, which is to say that, yes, it's still covered by Title IX. The new Title IX regulations really deal with sexual harassment, however. And so it's our opinion that, we think that complaints about things like different treatment or accommodations for pregnant and parenting students, athletics, discrimination, that's different treatment based on things like discipline or access to, other facilities, that those kinds of complaints would still be addressed under your more general grievance procedures and not under these new Title IX sexual harassment grievance procedures. So our next topic to discuss is the Department of Education's, and specifically the Office for Civil Rights, approach on the rights of LGBTQ students in schools. So just to give you a little bit of background before we delve into this, so OCR, if you recall, at the end of the Obama administration, was very strongly enforcing Title IX to protect students, particularly transgender students, who were seeking access to sex-separated facilities. So a fair number of high-profile cases that involved individuals who were seeking to use the bathroom or locker room that corresponded with their gender identity and were denied by schools and filed a complaint with OCR. And OCR was very, strongly enforcing Title IX to address that. At the same time, OCR has always, at least as long as I can remember, taken the position that discrimination based purely on sexual orientation is not discrimination under Title IX. So I remember my first complaint I received involving a complaint that a student was being bullied by other students based on being gay, and was sort of initiated into this process of deciding, is this discrimination based only on sexual orientation, only on the status of being LGBTQ+, or is it based on a failure to comply with gender norms? And if it was the former, we would dismiss the case. We would dismiss it, and there was language that we would use that said Title IX does not apply to sexual orientation discrimination. But if there were any allegations that the student was failing to comply with gender norms, then we would open the case. And it takes a little bit of mental gymnastics to do that, right? Because really, the failure to be attracted to someone of the opposite sex, it could be, I think many have argued that it is a failure to comply with gender norms, but the Department of Education had a pretty clear line about that. Now, that was under the Obama administration. When the Trump administration began, the Department of Education stopped doing transgender facilities enforcement. They said that we would not pursue any longer any cases that were involving a transgender student seeking access to a restroom or locker room of their choice. And they didn't come out with something formal to say that, but we just saw the cases just go away. We stopped seeing complaints, we stopped opening complaints, and this was when I was still in the office. So there was a definite shift in that approach. I referred to it recently in an Education Dive article as it's whiplash. We went from one approach straight into the opposite approach when it came to facilities. And there was a very high profile matter involving some K-12 school districts in Connecticut and a complaint by female students that allowing transgender female students to compete against cisgender female students in track was a violation of Title IX. And the Department of Education issued a decision back in May in a letter of impending enforcement, which is where basically you're at the very end of the investigation and OCR is about to threaten to take away your funds. And the Department of Education said to these Connecticut school districts and to the Connecticut Athletic Association, you can't allow these transgender female students to compete against cisgender female students. That is violating their Title IX rights. Well, in, I believe, June, the summer is really blurring together for me at this point, but I believe in June, the US Supreme Court came out in a decision called Bostock, or Bostock, not totally sure what the pronunciation is there, but they came out with a decision in which they held that Title VII of the Civil Rights Act of 1964, which prohibits discrimination on the basis of sex in employment, they held that that statute applies to LGBTQ individuals based on discrimination purely based on sexual orientation or other LGBTQ+ status. So this was really, many believe this was in conflict with the position that the Department of Education had been taking in both the transgender access cases and in the cases involving bullying, harassment, discrimination, different treatment based on LGBTQ status. So people were wondering, what is OCR going to do? And they answered that question for us on August 31st, 2020, when they issued 2 letters. One of them was a follow-up to that May Connecticut letter addressing transgender access to sex-segregated teams, and by contrast, also included in that analysis is sex segregated facilities. The other was a letter of investigation, a notice of investigation to an institution that we are opening up an investigation into alleged harassment based solely on sexual orientation. And what the department did here is they kind of split the baby. They said, okay, looking at Bostock and what the US Supreme Court's analysis looked like, we look at Title IX and we see that it uses the same on the basis of sex language that Title VII does. And we think that it applies. So we are now going to open an investigation and investigate this case involving discrimination based only on sexual orientation. So that is a big change in perspective by the department. And the fact that they issued a notice of, they publicly produced a notice of investigation, which we never really did at OCR. They did it because they wanted people to know that they've made this change. They've decided to treat these cases differently. But on the same day, they issued a follow-up letter in the Connecticut case addressing transgender access to that track team. And they said, we don't think that Bostock changes things with respect to sex-separated facilities like bathrooms and locker rooms or teams. And to do that, to reach that conclusion, they looked at the language of the Title IX statute, which allows, for instance, sex-separated bathrooms. And they said, you know, they also looked at the history of Title IX, which they said with respect to athletics for female students, that the very reason that Title IX was passed was to provide an opportunity for cisgender female students to participate against each other in athletics. And they, based on that, they reached these two conclusions. Some people are saying they think these conclusions are conflicting. If you want to see my interpretation of why I think they are relatively harmonious, you can check out our blog at title9insights.com, where it kind of goes back through what I just told you and also provides some insight into why this seems to just be a crystallization of the Trump administration's perspective on the issue of transgender access to facilities and teams since a consistent position that they've been taking with respect to that since taking office. Now, I already got one comment from someone who's saying, I'm in the Fourth Circuit though. What about me? Because the reason they're asking that is because there are two recent cases one was in the 11th Circuit, which has jurisdiction over Florida, Georgia, and Alabama. And the other for our friend here in the Fourth Circuit, which covers Virginia, Maryland, North Carolina, South Carolina, and West Virginia. And these decisions both relied on the Bostock case to hold in cases involving transgender student access to facilities that Title IX does protect transgender students, LGBTQ+ students, both when it comes to discrimination and harassment, and also in cases seeking access to bathrooms and other facilities based on gender identity. And this obviously directly conflicts with OCR's interpretation. Now, the Fourth Circuit decision is being appealed by the school district to the full Fourth Circuit. It was a panel decision, so it was only 3 judges. And if you look at the breakdown, it was 2 Obama appointees, I believe, and 1 George W. Bush appointee. It might have been H.W. But regardless, 1 appointed by a Republican president, 2 appointed by Democrat presidents. And so if you look at the breakdown that way, and particularly in the Fourth Circuit, I went to the University of Virginia, so I'm very familiar with the Fourth Circuit, and it's, you know, a relatively conservative circuit. We could see a different decision on appeal. We could. But even if we don't, people are thinking that this has got to go to the Supreme Court. And the Supreme Court was actually going to hear that Fourth Circuit case. They were going to hear it back in 2016, 2017, but they decided not to. They remanded it back to the Fourth Circuit to address the Trump administration's change in perspective on this. So I think that we could potentially see the Supreme Court wanting to weigh in on this. Until then, what do? Well, you are between a rock and a hard place. I don't have a perfect answer for you on this, because the thing is that if you you get a request from a student to access facilities based on the student's gender identity, and you say no, you can't because OCR will find that we violated Title IX. Well, that student is almost certainly going to file a complaint with the courts to say, you can't do this. If you get a request and you grant it, you could get a complaint from female students who are cisgender female who do not want to share facilities or teams with a transgender female, or from cisgender males who do not want to share facilities or teams with a transgender male. And so you're really between a rock and a hard place. And, with these types of decisions of how are we going to balance where what risk we want to take on, that's a conversation I'm going to want you to be having with legal counsel to really be thinking through and making sure that you're working with someone who's very familiar with the nuances so that you can come up with a plan of how to respond to that request, because it's going to vary significantly depending on things like your community, what their expectations are, the specific court decisions in your jurisdiction. Your state law is going to have something to say about that too, because we have state laws that have been interpreted to require access. But again, if you comply, are you violating Title IX? It is a mess. So I wish that I had a better answer to that question. But hopefully at least that has clarified kind of where things stand right now and what the stakes are with respect to this issue. And I've got here a quote from you from the judge that wrote the decision in the Fourth Circuit in the Gavin Grimm case, who said, at the heart of this appeal is whether equal protection in Title IX can protect transgender students from school bathroom policies that prohibit them from affirming their gender. U.S. Circuit Judge Henry Floyd wrote in the majority opinion, we join a growing consensus of courts in holding that the answer is resoundingly yes. So this was a full-throated declaration of support in the direction of recognizing transgender student rights, but it's bouncing off the walls of OCR, who have given us a resounding answer that the answer is no. So a lot of confusion here in this area.
So the Department of Education also made several revisions to its case processing manual. And that's a document that outlines the process that OCR uses to work through administrative complaints that it receives. And the first notable change is that institutions are now going to have the opportunity to review and correct any factual inaccuracies within resolution letters for cases where an institution is entering into a resolution agreement with OCR. OCR is going to provide the draft resolution letter and a proposed resolution agreement to the institution, and you'll then have 5 calendar days to inform OCR of any factual errors or inaccuracies. And this is an update that I think a lot of education institutions have been asking for. So we were thrown a bone on this one. And it's important to note, though, that the new case processing manual does not give institutions the right to demand changes. So if you if you do get one of these drafts and note any factual inaccuracies or errors, the OCR will take them into consideration and will take your feedback into consideration so that the final resolution letter is the most accurate that it can be. But there's no right for institutions to change certain facts.
Can I, if I could just say real quick one thing on that, Emily. So I forgot to look before we started to see if any of my dear friends from the Chicago office are on here today. But I do think that this is where it is really important to have good insight into the way that OCR works and how you can leverage this new right to help you in OCR complaints. And without going into too much detail on it, the idea here is just that this is giving us a right similar to the one that we've had with respect to resolution agreements. And if any of you have ever found yourself in a situation where you're trying to negotiate a resolution agreement with an OCR attorney or investigator as they near their 180 deadline, it is very stressful for everyone involved. And I remember the stress myself because you really want to get it done. But you want to get it done as the OCR attorney. But this is where it's going to be really important, even though you can't demand changes, this is your moment of strength. Just like when you're doing a resolution agreement, this is your moment to fight for yourself. And so you do have to know how to push to get changes that you think are appropriate. And it's worth doing, I think, because this is a big change and a very welcome one, I think, for the institutions, at least the ones we work with.
Thanks, Jackie. It's so helpful to have a OCR pro on our team. Give those insights. So another significant change that OCR added to their case processing manual is clarifying that OCR is going to interpret the statutes and regulations that it governs consistent with First Amendment requirements and principles. So this change really highlights OCR's recent focus on prioritizing free speech. And we may see this have, a significant impact, for example, in cases where it's alleged that inappropriate speech created a hostile environment, on the basis of sex or another protected class. We may, see this come in as, OCR not wanting to, take up those cases or not wanting to go too far in saying that, in abridging some free speech or potentially abridging free speech rights. And then for the first time, OCR also set forth the applicable standard of review for appeals for OCR determinations. So where OCR was previously silent on the standard of review, the updated case processing manual now states that OCR has to review appeals to determine whether there's a clear error of fact and or an error in the legal conclusion that changes the outcome of the determination. So the standard for review now is very clearly clear error of fact or legal conclusion that would change the outcome.
All right, so our last issue to cover before we open things up for questions is the recent, very recent issuance of a final rule involving many issues with respect to religious liberty, First Amendment, and academic freedom. One part of this final rule, which you can see in the last line here of this snip from the press release, is that the final rule provides clarity for faith-based institutions with respect to Title IX. And what that clarity is that the department has codified a set of standards that are used, that it has used over the years to consider whether religious institutions are subject to exemptions under Title IX. I would say on a scale of 1 to 10 of was this actually clarifying in nature, I would say it's like a 2. Because number one, they didn't even really include the list in the rules of the factors that are used. Those of us who work in this area know that those factors have been, they've been created over time through informal OCR decisions about whether to grant religious institution requests. And they, consider a number of factors that, I won't get into here other than just to say that the Department of Education, I don't think that they've basically ever denied a request for a religious exemption under Title IX, maybe 1 or 2. So this is not a terribly robust standard, but I suppose now that we know that the unwritten rules about what standards will be applied, which I believe have been being used for something like 30 years, they are now codified in this rule. Now, of interest to the rest of you on here who may be wondering, why in the world would Jackie and Emily think that we would care about this unless we're one of the many lovely religious institutions that we work with? But even if you're not a religious institution, and even if you're not a higher education institution, if your institution is a K-12, you should be aware and thinking about this issue here, and thinking about it in terms of what Emily just said about the updates to the case processing manual and the reference to the First Amendment there. And then also looking at this rule, which although only a small part of it addresses Title IX, the overarching impact of this rule is to say to higher education institutions, you better treat religious institutions fairly on your campus. And our definition of fairly is the Department of Education's definition of fairly, and you better comply with it if you want to keep getting federal grants from us. And even for K-12 institutions, hopefully you've been aware of the uptick in the number of changes the Department of Education has brought in the realm of First Amendment. And when it comes to Title IX, the reason that this is so important is because you are being asked now by the new regulations to play a gatekeeping function at the beginning of the complaint process and throughout the complaint process for discrimination based on sex, to say, is this conduct protected by the First Amendment? And if it is, the Department of Education does not want you meddling in it. And so you need to make sure that you feel comfortable complying with the First Amendment standards, which, mind you, are exceedingly complicated. So again, the takeaway, I think, for institutions, for you administrators, is that if you receive a complaint or a request or something that involves speech, someone said something to someone else, or that involves religion, like religious expression, or other political or other expression, you need to tread very carefully, because the Department of Education has made very clear that it is watching and that it intends to enforce this law very, very strongly. So the First Amendment is something that we need to be thinking about, and we actually are, for our K-12 clients, you will find very interesting our tomorrow's webinar, where we're going to be addressing First Amendment issues in the COVID era, and also in the era of Black Lives Matter, and other topics of that sort. So definitely check that out tomorrow. For our higher education institutions, I have on my to-do list the preparation for you of an alert in the coming days that will have information about First Amendment in your higher education context with respect to COVID. And if you are interested, we just got a question of how can you sign up for the K-12 webinar tomorrow. You can do so by going to our, you can just Google Franczek events, and our events page should come up and show you all of our upcoming webinars. You can also check out our past webinars there, which we have a number of them, including one on religious liberty in school, and a number of other webinars that you may find interesting that you can watch at any time on your own time. All right, and with that, we have had some questions of how to contact us. So you can reach me at jw@franczek.com. Emily, you are ET@franczek.com. That one's easy to remember. One of my favorite childhood movies.
It's like the alien.
Yeah, you look nothing like an alien.
Thank you.
And then also, please follow us on Twitter So we have our Twitter handles here. We also have our blog here, which is title9insights.com. And also, if you ever just want to, reach out to the Title IX team in general, you can reach us at title9@franczek.com, and someone will get back to you with a response. So we do have a couple of questions in the Q&A. I answered one of them, which was someone had asked when I mentioned earlier that we have materials that are available off the shelf, ready to go. How do you get that from us? So please just email us at title9@franczek.com, and we can send you information on our Title IX toolkit, which has the forms and notices and checklists that we were talking about. We can help you with our off-the-shelf website language that you can use. We have policy language. And lots of other materials that we have prepared over the past few months that, again, are ready to go, and with the goal being, just to try to make your life easier, and to be able to get you these things in a way that is that's not stressful, because you have enough stressful things going on. We had a question of, does Franczek offer an on-site administrator academy for a district administrative team? So this is a question for K-12 institutions in Illinois, and we have been beginning work on submitting for some administrator academies. I would recommend that you send us an email and let us know what your regional office of education or your intermediate service center is, so that we can make sure to submit a proposal there if that's something that you would be interested in. So please do let us know. We have been extremely flexible with people on training, so definitely just reach out to us if there's anything that you need. We've had some higher education institutions, for instance, that have said, we want some training for advisors, or we want some training for informal resolution facilitators, and those can be kind of hard to find. So we do have those options available in addition to the more the required training that needs to be completed. Oh, great question from someone as to whether this webinar is considered a training that should be posted on our website. I mean, I think the answer is no. And I'll tell you the reason why is because I don't think this is a training intended to help you with understanding the new rules or how to implement an investigation or the adjudicatory process under the new Title IX regulations. We did talk about some of the Title IX requirements, but a little bit more in a perspective of you need to do these things in time. But that said, there's no reason not to post the PowerPoint with your other materials. And particularly if you don't have a lot up there right now, it certainly isn't a bad idea to post any trainings that you do. And we did get a follow-up question of, do we need to post all training we've attended in relation to Title IX, or just the training on how to conduct our role in Title IX? For instance, I am the Title IX coordinator and investigator. Do I post trainings about how to implement the rule, or just trainings on how to conduct my role? So you are posting trainings you're posting all trainings that are dealing with your compliance with these Title IX rules. The purpose of the training posting requirement is to make sure that you aren't submitting yourself to biased training materials. That was what the department wanted why they want you to post things online. So I again think, I could argue in a court of law or in an OCR complaint that this training isn't that, because it's really, the title of the training is, what did I miss that's other than Title IX sexual harassment? But because we did touch on sexual harassment, I don't really see the harm in including it, and really including any training that you are participating in that is related to Title IX. So, I read it as, and Emily, I don't know if you agree, I read it as, if it's a training on Title IX sexual harassment, you post it.
Yeah, I'd agree with that.
Yeah.
We also got another question about posting anything from years past, or just since the new regulations are implemented. And I don't know if Jackie, you disagree, but I would kind of go along the same line of reasoning. Really, the rules are implemented for and require you to post the trainings based on these new Title IX regulations and requirements and all these new regulations around bias and conflict of interest. So that's what they're really looking for in terms of a posting requirement. But if you do want to post that you have this history of, you know, having consistent, very thorough Title IX sexual harassment trainings, you know, I don't personally see the problem with that. I think it gives you a good way to say, look at the history of, you know, my institution's really been on top of this. Our team has really been on top of this. But in terms of the actual requirement to post, it's just anything since the new regulations have gone into place.
Yeah, 100%. 100%. And I think a lot of this is, I mean, there's a reason why, for instance, we recommend, you know, I personally don't recommend for institutions that don't already have a Title IX webpage that's focused on Title IX to put things on the website that are only in relation to Title IX, for instance. I think you should have a much more inclusive approach. I mean, the department has given us a lot more procedural requirements with respect to Title IX, but they also still enforce other civil rights laws, and we still have other state level civil rights laws in all states, and those are important too. And so I think, you know, what Emily's saying about you may want to post more than what's required because it helps show your culture and your commitment. And similarly, you know, if you're putting up non-discrimination language that has, you know, a carve out discussion of Title IX instead of just making everything about Title IX, I think it shows you have a commitment to non-discrimination generally and not just on the basis of sex. The one thing you will have to keep in mind if you're posting past trainings is that they should comply with the requirements of the rules, and not in content, but what I mean is that if you have a training that you did and you go back and look at it and you think, this looks like it might have some sex stereotypes in it, or this looks like it might have some language that would suggest favoritism by the institution toward complainants, you're going to want to be very, very careful about posting that on your website right now, because you are holding it up as something that your team is relying on in doing their jobs. So I would suggest reviewing them before you post them if they're past webinars. Okay, well, it looks like we've answered all of your questions. I know a number of people commented about wanting to reach out. Please don't hesitate to reach out to us. We're always happy to answer your questions. Please check out our blog for more information. We try to update that with some interesting things every once in a while. So, and if you ever need anything, you can find us at title9@franczek.com. Thank you so much, everyone, and we hope you have a wonderful day and a wonderful week. Take care.